So that's kind of the overall list. And we believe that we've struck an appropriate balance. We obviously would have been happier if y'all would have conceded to some of our other requirements, proposals, and requests. But obviously, the fact that we've reached this TA, we think that this is balanced and sound and fair. And Devin, I want to turn it over to you. I know that several of these things, probably the first part of the list, directly relate to the civilian review committee and your role, so you may have some comments as well.
Yeah, thanks. So I just want to walk through a few of these and maybe give some examples and, so that we're all on the same page. I think we've got number 4 pretty much cleared out that we can take complaints online, anonymous, on the phone, verbally. But I want to talk about number 5. The CRP should be able to freely ask questions, which we've got in this TA. Subpoena witnesses and evidence. Obviously, we asked multiple times to try to get subpoena witnesses. That's not somewhere that the Office of Union will willing to concede. However, subpoenaing evidence, my panel in my office has access to all of the evidence in an internal affairs investigation. And so I'm not sure what the Democratic Party meant when they say subpoena evidence, because we already have access to all of the evidence. And then it says, listen to witnesses at the same time as the panel hears from police officers and union reps. And I think Will went into this a little bit. We don't hear from, neither me nor the panel hears from union reps at any point in the complaint process or in the CRP process. I guess it depends on how you define police officers. We do hear from internal affairs. They're the ones who've investigated the case, and they make a presentation to the panel saying, here's what was alleged, here's the policies that were alleged to have been violated, here's who we interviewed, here's what the testimony showed, here's what the evidence showed, and this is what we ultimately sent up to the chief. I think one clarification was that internal affairs used to actually make a recommendation on what the discipline should be.
Good point.
But under Chief Acevedo, they stopped doing that. And so now it's strictly just, here are the facts, y'all as assistant chiefs and chiefs make a decision. And then we have, obviously every complaint that's filed in my office is related to some alleged misconduct of some officer. That officer has the right to come and give his or her side of the story at the CRP meetings as well. But in my 10 years at the city, I don't recall even one case in which the officer actually came. So when they say they should hear from witnesses at the same time as they hear from police officers, the alleged officer who's alleged to have committed a policy violation has never, in my experience, actually come to the CRP to give their side of it anyways, and so I'm not really sure what that meant. Number 6, the OPM should have the power to initiate investigations even if a citizen does not file a complaint. So I think with this TA, we've got the ability that even if things are not under oath, we can forward that and initiate an investigation at APD. So we've completely changed the definition of what a complaint is. But I think you guys agree that, let's just say no one has sent me or my staff anything about a alleged policy violation. Well, let's just say it's something we see on our own. We're walking down the street, or my staff sees it in the newspaper or something. There's nothing in this contract that prohibits us as citizens of Austin from initiating, from sending an email to our work email address and then forwarding that on to the chief and initiating an investigation that way. So, I feel like the OPM does have currently and easier access to do number 6 with this new contract that's approved. And then number 8, the reports and recommendations should all be released to the public, basically without going through city legals and their determination as to other possible exceptions to the Public Information Act. And in addition to what Lowell said, I just want to go through it. Our contract, I think currently has 7 things that can be made public, that a panel does, and in our tentative agreement, we've increased that to 9 things. And it clearly says if, for example, if we're making a policy recommendation, which we can do now, you're gonna make a policy recommendation because you somehow got a complaint filed, and that's how the CRP got the case in the first place. So for example, let's just assume that, this would be a hypothetical policy recommendation that would become, public, once the CRP, makes it and once the chief makes a decision on the case. I'm completely making up all these facts. But on June the 6th, 2017, the panel heard from complainant Joe Smith, who alleged that Officer Mary Johnson violated policy when she made Mr. Smith open his trunk of his car to take a look inside. The investigation found that Mr. Smith should not have been forced to open his trunk. We recommend that APD change the policy on how officers adopt search and seizure law. And so, number 8, really, through this contract, we've increased the number of recommendations that the panel can make, and in addition, we've increased the number of recommendations that can become public. And so, I think that by and large, for the most part, I still see benefit to getting it double checked by city legal, because there are things that we may not be aware of that are prohibited in some other, portion of the law. But I think through this contract, it's made it much more clear as to what's public and what's confidential, and I appreciate you guys' willingness to work with us on that. I think that's it for my portion of the meeting.
Larry, you have anything? I'll turn the floor over to you.